Warm greetings everyone. I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. Today we are going to discuss a very sensitive matter and a very important issue, that is the history behind Sati practice, Sati and its prohibition under law. The learning outcomes of the present module will be to learn about the meaning of Sati Pratha. Secondly, to understand the historical perspective of the subject matter. We will also discuss the relevant provisions of law relating to the prohibition of the Sati practice. Dear learners, let's start with the brief overview of the topic. The ancient Hindu tradition called Sati, wherein a widow would throw herself on her husband's pyre and burn to death, was initially a voluntary act, considered courageous and heroic, but it later became a forced practice. Sati originally meant a woman who performed the act of immolating herself after her husband's death. The word is derived from the Sanskrit word asti, which means she is pure or true. In mythological terms, Sati was the name of the wife of Lord Shiva. Her father never respected Shiva and often despised him. To protest against the hatred that her father held for her husband, she burned herself. While she was burning, she prayed to be reborn as Shiva's wife again. This did happen, and her new incarnation was called Parvati. People used to justify the practice based on this tale. But when Sati burned herself, she was not a widow, and thus the practice is quite unrelated to this tale. Dear learners, let's go through the history of Sati Pratha. Although Sati is now banned all over India, it has a dark history. Historical records tell us that Sati first appeared between 320 CE to 550 CE during the rule of Gupta Empire. The first explicit reference to the practice in Sanskrit appears in great epic Mahabharata, compiled in its present form about 400 CE. Incidents of Sati were first recorded in Nepal in 464 CE and later on in Madhya Pradesh in 510 CE. The practice then spread to Rajasthan, where most Sati cases happened over the centuries. It is also mentioned by Diodorus Siculus, a Greek author of the 1st century BCE, in his account of the Punjab in the 4th century BCE. Numerous Sati stones, memorials to the wives who died in this way, are found all over India, the earliest dated 510 CE. Ibn Battuta, an Arab traveller, observed that Sati was considered praiseworthy by the Hindus, without however being obligatory. Historically, efforts to prevent Sati by formal means existed even before the Mughal rulers came to power. Under the Delhi Sultanates, permission had to be sought prior for Sati to be committed. In time, this check against compulsion became a mere formality. In any case, Hindu women from royal families continued to burn unchecked. Humayun tried to prevent Sati, but eventually withdrew a royal fiat against it. Akbar insisted that no women shall commit Sati without the specific permissions of his kotwals. Children were strictly forbidden from the practice. The later Mughals continued to put obstacles in the way, but the practice carried on in the areas outside Agra. Initially, the practice of sati was confined to royal families of Kshatriya caste and only later spread to the lower castes also, becoming widely practiced amongst all the social classes of India. Sati was at its peak between 15th and 18th centuries. During this period, as many as 1000 widows were burned alive every year, most commonly in India and Nepal. However, records show that the practice was also popular in other traditions and in countries like Russia, Fiji and Vietnam. The larger incidence of sati among the Brahmins of Bengal was indirectly due to the Dayabhag system of law, which prevailed in Bengal and which gave inheritance to widows. Such women were encouraged to commit sati in order to make their inheritance available to other relatives. In the 16th century, steps to prohibit sati were taken by the Mughal rulers Humayun and his son Akbar. Sati became a central issue under the British Raj, which first tolerated it, then legalized it by legislating conditions under which it could be done, and then finally in 1829 outlawed it, using the condemnation as one of its justifications for continuing British rule of India. Now let's see what were the different ways of execution of sati pratha. Various accounts tell us about different ways in which the ritual of sati was carried out. Most accounts either describe women seated on their husband's funeral pyre or lying down next to the dead body. Some say women would jump or walk into the pyre after it had been lit, while others report that women would sit on the pyre and then light it themselves. The practice also varied from region to region. In some places, a small hut was constructed for the widow and her deceased husband. In several other regions, the corpse of the husband was placed in a pit along with flammable raw materials, and then the widow was required to jump in after the fire had been lit. Some less torturous methods of execution were also prevalent back then. For example, before being placed on the funeral pyre, a woman could take poison or drugs so that she would either start dying slowly or at least become unconscious. Sometimes the widow herself would get snake bitten or use a sharp blade on her throat or wrist before entering the pyre. There were certain societal exceptions to this practice, certain rules that exempted some women from this practice. The first rule stated that any widow who was pregnant, menstruating or had very young children could not partake in this ritual. Women who committed sati were said to have died chaste, which people believed meant she would have good karma and a much better life in her next birth. But this justification didn't work for Brahmin women, as they already belonged to the highest caste. So karmically, they couldn't benefit from sati and thus did not have to practice it. Then there is a different version of sati, that is Johar. Women sometimes suffered immolation before their husbands' expected death in battle, in which case the burning was called Johar. In the Muslim period, the Rajputs practiced Johar, most notably at Chittorgarh, to save women from rape, which they considered worse than death, at the hands of the conquering enemies. The hardships encountered by widows in the traditional Hindu society may have contributed to the spread of sati. There were various aspects to this practice. First is religious aspect. According to ancient Hindu law, Stri Dharma for women entails devotion to one's husband. Her only concern is to perform properly any of the services demanded by her husband. Such a woman is attached to her husband even after he has died. Total subservience is enjoined, and the ultimate expression of such complete marital devotion was expressed in sati. Then, economic and political aspects. Insofar as the community is concerned, there is an economic gain to be made from the commercialization of a sati and the worship surrounding her death. The latter practice is illustrated by Roop Kavar's story. The proponents of sati glorified her sacrifice by having town celebrations and by constructing a temple in her honor, without interference from the authorities. In 1990, 400 people attended a celebration of her death, even though the celebration was banned. An article in Women, Law and Development, Action for Change points out that the region where this incident occurred is a fairly modern one, where the literacy rate is relatively high. Now let's see the journey of prohibition of sati practice. If historical facts are to be believed, the practice of sati was prohibited many times between 15th and 18th century. As discussed earlier, Mughal Emperor Akbar outlawed sati, and then Aurangzeb in 1663 tried to end it again. Even the Portuguese, French and British, who came to India during the European colonial period, tried to stop sati. In 1850, the British hardened their rules against the practice. Sir Charles Napier ordered the hanging to death of any Hindu priest who presided over a widow burning. The princely states of the India during that time were also pressurized to rule out sati completely. Raja Ram Mohan Roy was one of the key reformers who opposed the practice. British regulation. The British were by no means certain of their approach to the custom, no matter how abhorrent they found it. Following the Mughal example, for a while they tried to regulate it by requiring that it be carried out in the presence of their officials and strictly according to custom. Perhaps Bentinck was spurred onto legislation by the unacceptable rise in sati in his province Bengal in 10 years between 1815 and 1825. The figure had doubled to 639 deaths by burning. He was certainly under pressure from the constant entreaties of missionaries and encouraged to action by change being brought amongst an influential sections of Hindu led by Raja Ram Mohan Roy's Brahmo Samaj. Lord William Bentinck passed the sati regulation of 1827 on 4th December, after assuming the governorship of Bengal. The regulation was clear, concise and unequivocal in its condemnation of sati, declaring it illegal and punishable by the criminal courts. The Commission of Sati Prevention Act 1987. Now, what are the relevant provisions of this act? The Commission of Sati Prevention Act 1987 consists of 22 sections. In 1987, in the village of Deorala in Rajasthan, an 18-year-old married woman named Roop Kamar was forced to become sati when her husband died after 8 months of marriage. She refused, Consequently, a group of men from the village forcefully drugged and immolated her. Police investigated the case and those men were arrested. In light of this incident, the government created the Prevention of Sati Act, making it illegal to force or encourage a woman to commit sati, and anyone doing so would be punished by death. And yet, some widows still choose to become sati. At least 4 such cases were recorded between 2000 and 2015. The Bengal Sati regulation, which banned the sati practice in all jurisdictions of British India, was passed on December 4, 1829 by the then Governor General Lord William Bentinck. The regulation described the practice of sati as revolting to the feelings of human nature. Indian society might have progressed and moved forward, but the social evil of sati continues to hang around in Indian society. The shocking incident of a 71-year-old woman performing sati in Chhattisgarh in 2008 is an eye-opener. The practice of sati has been a part of Indian society for ages, with its inception being traced to the time of Gupta period. Though sati is illegal and is highly condemned in Indian society, the act of sati being performed in the 21st century has shocked people. Lalmati, aged 71, resident of Chechar village in the Raipur district in Chhattisgarh, had come to the funeral pyre of her husband Shivanandan and dressed in a new sari. When the husband's body had been almost burnt and the villagers were about to leave, Lalmati jumped into the pyre and was reduced to ashes in moments. It is yet not known whether Lalmati chose to do this voluntarily or was pushed by someone. A police case was filed and the investigation lingered on for a long period of time. But the incident is a glaring example of how such incidents continue to occur in rural India. Sati was never widespread and it has been illegal since 1829. But a few cases of sati still occur in India every year. In choosing to die with her husband, a woman gains great merit and power and is thought to bring kudos to her husband's patrilineage and to others who honor her. Thus, through her meritorious death, a widow avoids disdain and achieves glory, not only for herself but for all of her kin as well. As discussed earlier, in September 1987, 18-year-old Roop Kanwar, a young widow, she was just married for 8 months, of Rajasthan, was forced to commit sati after the death of her husband. Many liters of ghee were poured on her as she burnt to death on her husband's funeral pyre. People who assisted her in suicide were arrested. But Roop Kanwar is idolized and has attained the status of a deity. A temple was built for her. In October 1996, the Indian court upholds the suicide as a social tradition and acquitted all the 38 defendants who assisted Roop Kanwar. Another incident was the case of Kutubai. A 65-year-old widow committed sati in the state of Madhya Pradesh. Another was Vidyavati, a 35-year-old woman committed sati by jumping into the blazing funeral pyre of her husband in 2006. Janak Rani was burnt to death on the funeral pyre of her husband in Madhya Pradesh in 2006, and Lalmati of Chhattisgarh committed sati in 2008. In some regions of India, women are still treated as appendages to their husbands and are expected to either follow their husbands into death or to remain chaste throughout their widowhood. Social pressures to commit sati remain strong in certain areas of India. But nowadays, the people are being aware of their rights, and also the condition of women is improving, and it can also be improved when all the people understand and help the women who are still facing problems in some regions of India. The Commission of Sati Prevention Act 1987 substituted the various legislation that had been operative in different parts of the country with a central law that sought not only to prevent and punish the commission of the act itself, but also to make any glorification of the act of sati an offence. There are provisions in the act to take action against exploitation of such criminal occurrences either for financial or political purposes. Specifically, the act makes a criminal offence equivalent to murder the abetment or encouragement of a sati or an attempted sati. Such action is liable to a sentence of death or life imprisonment with an appropriate fine. Sati means the burning or burying alive of any widow along with the body of her deceased husband or any other relative, or with anything or article associated with the husband or such relative, or any women along with the body of any of her relatives. Such burning or burying may either be voluntarily or otherwise. The person committing sati is herself liable to prosecution for attempted suicide, the penalty being a year's imprisonment with a fine. Further, glorification of sati is defined as the observation of any ceremonies or the taking out of the processions in connection with the incidents or practice of sati, the support, justification or propagation of the practice, or the arrangement of or participation of any function to eulogize a person committing sati, the creation of a trust or fund or collection of donations for the purpose of a temple or any other structure with a view to perpetuate or honor the memory of a person committing sati, or the performance of any ceremony for the same purpose. Under the Act, all temples dedicated to such practice or persons are liable to be removed. The penalty for glorification of sati is imprisonment from 1 to 7 years, a fine of 5,000 to rupees 30,000, and the confiscation of all assets collected in the name of sati. Special courts equivalent to sessions court are to be convened for the trial of offences under this Act, with judges of equal powers. All such cases are to be tried without delay, there being required reasons to be furnished if trials are adjourned beyond the next day. The onus of proof of innocence rests with the accused. No person who had abetted the commission of sati may inherit the estate either whole or even in part of the deceased women. Convention on the Elimination of Discrimination Against Women, that is CEDAW Convention. Violence against women is a global problem. Violence against women manifests itself as rape, molestation, stripping, kidnapping and abduction, domestic violence including wife battery, dowry death, cruelty to women, driving them to commit suicide, or other forms of murder like female feticide and sati. A convention on the elimination of all forms of discrimination against women was adopted by the General Assembly of the United Nations on December 18, 1979. The convention came into force in the year 1981. Consisting of a preamble and 30 articles, it defines what constitutes discrimination against women and sets up an agenda for national action to end such discrimination. India has ratified CEDAW, although the International Bill of Human Rights laid down a comprehensive set of rights to which all persons, including women, are entitled, additional means for protecting the human rights of women were considered as necessary, because the mere fact of their humanity has not been sufficient to guarantee women the protection of their rights. The preamble to CEDAW Convention explains that despite the existence of other instruments, women still do not have equal rights with men. Discrimination against women continues to exist in every society. Dear learners, after the foregoing discussion, one may conclude that Sati was the Indian custom of a wife immolating herself, either on the funeral pyre of her dead husband or in some other fashion soon after his death. According to ancient Hindu customs, Sati symbolized closure to a marriage. It was a voluntary act in which, as a sign of being a dutiful wife, a woman followed her husband to the afterlife. It was therefore considered to be the greatest form of devotion of a wife towards her dead husband. However, with time, it became a forced practice. Women who did not wish to die like this were forced to do so in different ways. Traditionally, a widow had no role to play in society and was considered a burden. So, if a woman had no surviving children who could support her, she was pressurized to accept Sati. Keeping in mind the India's ratification of United Nations Declaration of Human Rights, the CEDAW Convention, and also the enactment of Sati Act, provisions of all these laws must be applied in their entirety. It is essential that women shall be empowered through education and financial independence. The patriarchal mindset of the society needs to be changed. With this, the present module is concluded. I hope it enriches your knowledge on the topic. Thank you very much.